Raise your right hand. Do you solemnly swear the testimony about to give in this matter will be true, nothing but the truth, so help you God?
I do.
Thank you.
Mr. Burns, please give us your name and address.
Robert Edwin Burns, 4155 Benson Lane, apartment 228, Baton Rouge, 70809-2152.
And you are a licensed holder with the Louisiana Auctioneers Licensing Board.
Yes, sir.
And your company name is Auction Sells Fast, is that correct?
That is correct.
You were in here and present when we went over these various documents. Do you recall receiving these documents that we went over at approximately the time I went over those?
I do recall receiving each of the documents that you make reference to.
Did you prepare a response to any of the allegations, either in the original amended complaint or the complaint?
The original complaint asked for nothing. It was a series of threats, of litigation against me. No, I did not.
In reference to the allegations in this particular complaint that was provided by New Orleans Auction Galleries Incorporated, did you make these statements that are indicated in this document?
I would ask the counsel to point out specific statements.
Let me show you, it says additionally on November 15th, Burns, and it's reference to a specific allegation that was supposedly made.
What exhibit is that, I'm sorry?
This could be on page 1 of the
He's looking at Exhibit 1,
Exhibit 1.
which is the original complaint.
I'm sorry, I didn't repeat the question, Counsel.
Did you make any false statements about New Orleans Auction Gallery?
I made one statement that was technically inaccurate. One. I'm happy to specify what that is. And it goes to the quotation that you're making here.
And what was that?
That one statement that I made that was technically inaccurate was when I said that the previous day the federal bankruptcy court had denied the motion to disband the Unsecured Creditors Committee. And I have the actual filing from the PACER system from the bankruptcy court. What actually was denied was the motion for the expedited hearing to hear the matter of disbanding the Unsecured Creditors Committee. That was a technical error on my part as a result of having read numerous documents. That is the only technical error I made. I certainly, well, first of all, I didn't make any testimony, period. It's not on the road. But other than that, no.
So in reference to this comment that you made about the unsecured creditors and the dismissal of the disbanding of the committee, did you later correct that on your website?
Yes.
And when did you do that?
At the point that late March, when I believe it was March 23rd, and I can get Mr. Peck references the date at which it was actually April 3rd. I'm sorry, April 3rd.
And
It was actually denied.
my question was, did you in fact correct your error on your website?
I never made it. You talked about what we said here. Are you saying that I said on my website that motion had been denied?
Mr. Burns, you need to answer my question.
I'm trying to.
Did you said something in error, correct? Or you wrote something in error?
No, I did not. What I said was, at that November 15th meeting, which is the highlighted text that you have, counsel, yes, I made one technical error. It's pretty immaterial, but yes, my statement that the Unsecured Creditors Committee, that the motion that Mr. Stewart Peck made the day before had been denied was incorrect. It was the motion for an expedited hearing that was denied.
So there was no attempt to disband the Creditors Committee?
Yes, there was an attempt to file the motion.
And it didn't happen, though? You indicated that it did, in fact, happen.
I didn't say the Creditors Committee was disbanded. That's completely false.
Let me show you, and I'll mark this as exhibit number 7 and ask for you to examine this document, which is a letter addressed to you and to Mr. Phillips, dated April the 3rd, 2012. Do you have a copy of it?
do you have another?
Are you intending to offer that?
Yes,
Mr.
I am.
Bankston? I would object.
So he has to show him the letter and see if he can identify it. Mr. Burns, you should have access to those documents at your house.
You ready? Are you familiar with this letter dated April 3rd, 2012?
Yes.
Indicated in a letter that you made a false statement before the auction board regarding the debtor. And then reading from the first full paragraph, second full paragraph.
Your Honor, if I may interrupt, we're now going beyond the complaint that was filed in here. We've got Mr. Mr. Peck, Luganville Firm's letter that he's attempting to cross-examine this man on a fact that is not even correct by the first document that he used. The attachment to the complaint states that the motion to disband had been filed, and that was the question that Mr. Bankston asked this witness immediately prior to going to this document.
Your objection is as to relevance.
Well, relevance, and I know you can let hearsay in, but this is well beyond the realm of something pertaining to the complaint itself. We have the complaint in the evidence, and now we're going to a letter that was written outside of anything we're doing with this board, and Mr. Bankston is attempting to use that to somehow cross-examine this man about a fact that's in the complaint that's filed in the evidence.
Mr. Bankston?
Well, Your Honor, in reference to the statement that he had, the statement that's referenced here is further amplified in a letter he was warned even previously about making this false statement. And in this particular instance, this is just a further letter to him about that specific issue that was sent to him before the complaint was filed.
The question that counsel asked was it his position that a motion to disband was not filed? And it was, and it's clearly established here. I think Ms. Jacobs has a question.
Yes, ma'am.
Your Honor, I would like to be furnished with a copy of LARS 37:3121A. And I'd like the other board members to have a copy of it, since this is what Mr. Burns is accused of violating, and I would like to see if this particular hearing meets all the requirements in that. I mean, I think that's important.
Well, what we could do, we could have a short recess if you would like a copy of that.
I think I'd like every member to be furnished with a copy of it.
Okay. What we could do here, is there someone here from the staff that is able to go?
I have a copy of the statute in my vehicle. I don't have a copy machine here.
They should have access, should have a copy machine.
I mean, I can ask them.
Yeah.
They're very specific in not sharing certain things with us.
It's on the AG's
I'd like to have a copy of that.
If you could make a copy.
And tell me the specific
It's
statute.
Title 37, is it 3121?
3121A is the only one that I believe he's accused of violating.
Correct.
3121A?
Yeah, you can do that now. And is it okay because she's going to do that?
Yeah,
now?
absolutely. You can
Okay.
continue on, but I need a copy of that before I can say whether or not he's violated anything.
Right, that's understandable. Now let's get back to this letter. Your objection is based on relevance, and Mr. Bankston, I believe you're in the middle say why it is relevant.
Well, this was a letter that was a precursor to the filing of the complaint, in which they further amplified the violations that he was making and the information that he was providing that was false.
Give me a second.
Mr. Burns, it says in your November 15th comment, last night they filed and a judge denied that motion. We're referring to the disbanding of the committee.
That is correct, and I told you that was the one technical error that I made, and I admit to that.
And when did you admit to that?
Meaning
Today, I know you admit to it, but prior to that, when did you make that correction?
Everything I have done, Mr. Bankston, I have done in consultation with the council, so I can't give you the exact date that I made that admission to him.
Well, the issue is, did you tell the members of this board or publish in some way the error of what you produced?
That's not the issue, Your Honor. It subsequently was denied. Was he supposed to admit back in November after it's been denied? I was wrong when I said the motion was denied. It was an ex parte motion. After the motion that he's talking about was subsequently denied by the bankruptcy court. His error was when he told the board the motion was denied. It was in fact a motion for expedited hearing. He made a mistake. He's admitted it here. But the motion was ultimately denied. So was he supposed to go back and say I was wrong? No, the motion was denied. I was wrong at the time.
Well, I don't think that the question is, was he supposed to? I think the question is, did he? I think that's the question.
Did you?
Wait. Is he saying, did he advise the board that it was a mistake, or did he advise Mr. Peck, who's really not relevant whether he advised him or not?
He can ask the question, did you do something? Whether or not he was supposed to do something, I think that's an argument that jury would make. But
Fair enough.
He can ask him, did he do something?
Did you
Did he what?
advise anybody that you made this error?
Yes, my counsel, after I got the letter, when you had the letter in front of you, that prompted me to go back. I have it on a CD right there. At the time, every filing made with New Orleans Auction Gallery. There's now, as of about a week ago, 506. So I think I did pretty good to make one small error. But yes, now, and I don't see the technical relevance of it in any regard. Attempted to disband the creditors committee.
Mr. Burns,
Mr. Peck.
Mr. Burns, you're not answering my question. You're certainly willing to allow to explain your answer. But once you receive the complaint that was filed in this particular case and pointed out the error as it relates to that complaint.
Your Honor, this should be addressed to you. You should not be arguing with the witness.
Once you receive the complaint, it gives you an opportunity in the complaint process to purge yourself of the error. Did you do that?
I wasn't aware I had made the error.
Even though you read the complaint?
That is correct. I had to dig through 506 documents to find out what the nature of my error was.
Did you have any grudge against New Orleans Galleries?
Absolutely not.
You were involving yourself in the aspects of trying to, I guess the best way to kind of put it is that dissemination of stuff involving the bankruptcy, trying to affect the bankruptcy.
I made no attempt to affect the bankruptcy. My involvement with New Orleans Auction Gallery was no different than my involvement with numerous other auctioneer licensees that have appeared before this board or had problems or didn't conform to auctioneering statutes, which escrowing the funds is one.
On your website, did you attempt to disseminate information concerning the bankruptcy and whether or not the bankruptcy should go forward in certain aspects?
Whoa. It has nothing to do with testimony before the board. The complaint and the information that counsel has thus far introduced concern his relatively inaccurate statement about the dismissal. Whatever he's put on his website, it's not not testimony before this board. It has nothing to do with these proceedings, Your Honor.
Well, Your Honor, the allegation in the complaint indicates, and I'll read that portion that says, that at the time Mr. Burns made statements regarding the motion to disband the Committee for Unsecured Creditors, the motion to disband was pending before the bankruptcy court and had not been ruled upon. What he was saying was false. To say that the motion to disband the creditors had been denied. It also indicates that he was taking positions that were attempts to, in effect, mislead concerning the debtor's finances and the recoveries available to the creditors.
And what's your question? Can you repeat the question?
Well, the question was, do you deny the allegations within this complaint?
Absolutely, and in reference material from my website, I would appreciate you leaving it off to.
Did you in fact disseminate documents which were intended to inhibit the ability of New Orleans auction galleries to reorganize under the bankruptcy?
Absolutely not.
You didn't do that?
Absolutely not.
Did you in any way solicit authorization or rejection of the bankruptcy plan? Suggest that?
Absolutely.
You know, what does that have to do with this hearing?
Yeah,
Absolutely not. Okay, I'm sorry.
yeah, I think we need to focus a little bit on the false statement aspect.
Once you received this letter, which is marked as exhibit number 7 on April the 3rd, did you respond in any way to the allegations in this letter?
Submitted the material to my attorney, and I have followed the advice of my attorney from the day that letter arrived until today.
Did you give anything back in reference to the complaint as it relates to this letter in any way?
To the extent he's asking for privileged communication from counsel, object and direct my client not to answer anything that would have to do with confidential communications.
You can answer without giving any type of confidential information answer.
I have forgotten what this question was.
Did you respond to anything related to this letter as it relates to providing information to the board?
I responded to no one.
Other than your attorney?
I don't recall the letter asking for a response. In fact, I have it in front of me.